Thank you, Madam President. I was waiting actually to find out whether Senator Hanfield was going to vote yes or no on this bill. I couldn't determine it.
Enigmatic.
Because there was a publicly announced position. Well, it wasn't on the record in this position, so you say it hasn't changed. And the reason is because across the floor, when we were on our seats, the senator asked the question of why, something like, why was I spending so much time on him? I think he said it in a jocular fashion.
You have a fascination.
No, sorry. Please, don't put these things in personal terms, man. I'm not in here for no personal
like
thing,
how
right?
you with Marlon. It's politics.
No, and it isn't, I don't even know that it's politics. As I was saying to the President of the Senate, it's a structural issue I'm seeking to discuss. These institutions are important to me. These institutions are not a joke, right? So I'm trying to make a serious point. And I made the point I was making was not personal to you. It was not personal to you. The point is, if you are, as was announced, the whip of the government is supposed to speak with one voice. Well, I mean, all of that stuff came out later in here. There is an official voice, so on and so forth. But as far as we were concerned, the Senate had a whip. And the whip is Senator Hanfield.
Yes.
Up until today, there was no qualification on that. Yes. The point I was making is, the whip is at one with the cabinet. And when the cabinet presents something, the cabinet speaks with one voice.
That's why I told you.
I am saying that up to this point, that point was not until this morning. And so the only issue.
I think I made it too privately.
No, sorry. Exactly. And I'm saying if you have institutions, they perform in a particular way. And the government speaks with one voice.
Just one. I think...
Chair recognizes Senator the Honorable
Thank you.
Carl Bethel for this time.
Thank you. For clarity and for the true record, I think I would suggest that my friend opposite make it clear that what he is saying is that until this point in terms of the public discourse, that wasn't made clear. But he and I have had our exchange on this issue, so it was made clear, but not publicly. That's the only point I want to make.
Okay, yeah, we are public officials, man. We're not private officials. No, and I'm not conceding that because I don't even remember it. But what I'm saying is, the only thing I'm answering is this. Do not make this a personal thing. It isn't. It's a structural thing. And if you say someone is the whip is as one with the cabinet. That is the point I'm making. Yes. And you can try and, minimize that and say whatever and so on and so forth. That's the point. That's the point.
I told you that.
That's the point. And treat the institution properly. Now, as it relates to how these bills came here, I heard all the back and forth and twisting and turning and so on and so forth that was going on. The position was adequately, as I can tell, settled by Senator Johnny Ann Dorset, which is the Privy Council makes a decision on a ruling, in 2011. That ruling was on the constitutionality of Section 5 of the Listening Devices Act. It was challenged by someone named Maycock, who must have been the subject of the Listening Devices Act, and his lawyers were attempting to exclude certain evidence because they said that it had been captured unconstitutionally. The Privy Council reviewed all of the law, and as best I can understand the judgment in 2011, they said that even though there were issues relating to the modern and accepted standard and practice, because of something called the Equal Law Amendments.
Pre-existing law.
It's called the Equal Law Amendment Act, or Equal Law Amendment Rule in the Constitution.
It's pre-existing law.
Right, which says that, essentially, in a lot of complicated language, some people said the drafting was bad, but
It was bad.
complicated language, anything which was constitutional before 1973 could not be challenged on the grounds of constitutionality after 1973.
Any law.
Right.
Any pre-existing law.
Now, they sought to make a distinction between executive action and law, but that also had a problem, because Privy Council says, so, bottom line is, notwithstanding all of it, they said, at the end of the day, even though it does not match up to the present constitutional standards,
Right.
we need to,
Consider.
we uphold the law because it does not violate the present constitution, but impliedly said perhaps the legislature ought to look at this again.
Yes.
That's how the bill got its genesis.
Right.
Now, the difficulty you always have is, when do you do these things? Law reform produces a lot of things. Problem is that it came at the end of the term and
When do you increase that?
became fodder for an election. So at that point, no rationality could prevail. And everybody had gotten their buzzwords. Our friend opposite had decided it was a spy bill and so on and so forth, and their friends in the media just went crazy with all of this nonsense. When you look at the text of both bills, you'll find that the changes are minimal. But essentially, the regime is the same. Regime is the same. And so the modern practice and standard, Madam President, is to allow a judge to review the applications. So it's just not a political figure that's doing it. That's the whole idea. And that regime is what obtains in the present bill. And nothing that has, in terms of the amendments, okay, we hear about an offense and so on and so forth. I mean, we can argue that back and forth all day, but the question is, it goes before a judge, and the judge makes a determination as to whether or not this should take place. And this brings it into conformity with the modern standards, but there's a subtext which I find very interesting that in our country about this whole question of listening devices. In a society where privacy has morphed so far from what I remember and understand from growing up to today, where I don't know if, I'm going to call them kids, but the people who are much younger than me actually know or appreciate or care what privacy is. Because it appears that in everything we do these days, privacy has gone completely out the window. But as the senator said, she doesn't want anybody listening to her conversations. She did go on to say she can't imagine why they would want to do that, but that isn't the point. The point is, it's your conversation, it's your image, it's your home, it's your life, and you ought to have the right to protect the privacy of your domain. Your thoughts, your opinions, your speech, all of those things ought to be private. And there are compelling reasons for doing so, even if it's just because you want them to be private. And that's something which I think has sort of gone out of the window. People casually say, well, I know all my conversations are being recorded. The other day I called a businessman and he didn't answer the phone. A few minutes later, he calls me back on WhatsApp. So I said, with a different number. So I said, well, what's this?
What is businessman is?
Huh?
He don't deserve it.
He says, well, I have to make sure because everybody's listening, people are listening to my telephone conversations. So there's a feeling around the country that every conversation that you have on a phone is being monitored and listened to by someone. And I come to that. As foreign minister, we were sucker punched with this report that our phone calls were all being listened to. And they said that the report says that using the lawful authority to monitor the activities of drug people, they were using this as a backdoor to monitor all conversations in the Bahamas. So as foreign minister, I'm tasked to address that issue. And we could, well, you know, on the one hand, on the next hand, on the other hand, so on and so on. Finally, we got from the Assistant Secretary of State a paragraph which essentially said, going forward, we will use the lawful authority for the purposes for which they were granted. And
Stopping drug trafficking, terrorism, that's it.
well, hopefully, that's what it is. But in the modern era, that is what we face. And I see in the discussions which we had here in this place when I was talking about the legislation to do with Financial Transactions Reporting Act and this assault, for example, on cash. And everybody wants to make it a cashless society. And this is supposed to be the panacea for all the problems. And of course, you know that once you start talking about electronic and cashless and all the rest of that, everybody has a perfect record of what you're doing at every stage along the way. So again, the exchange that you're making for this so-called advance into electronic or cashless society is a loss of privacy. So we have to continue to think about it. So I want that to be clear from our side. Our colleagues have advised us in the other place that all of the objections that were raised were accommodated by the government. And so we see no reason fundamentally to object to it and will vote to support it as precisely the update in the standards and a modern tool to fight crime. So that's the basis of it. So that in sum is where we are, and I'm still going to see how this vote goes, whether it's yes or no, because the proof.
Are you trying to intimidate my
No,
independent
the proof
senator?
is always
You're trying to intimidate-
in the pudding.
you're trying to
Thank you, ma'am.
You're trying to intimidate
Thank you,
my independent senator.
As many